ex-boyfriend, 22-year-old landscaper Scott Gifford, for stealing her wallet and using her debit card. Scott says he didn't do it.
Order. All rise. Quiet in the courtroom. This is case number 577 on the calendar in the matter of Soule versus Gifford. Parties have been sworn in. Judge, you may be seated. Folks, have seats, please.
Miss Soule, you and the defendant have a child together.
Yes.
According to your complaint, the defendant came to visit the child and stayed overnight. Mm-hmm. You claim that he stole your wallet, which contained your debit card, and used it to the tune of $175.
Yes.
And the defendant says he didn't do it. Now, you didn't see him take your wallet.
No, I did not.
But you had your wallet when he was there.
Yes, I did.
And then from your complaint, when he left, you went to work the next day and you didn't have your wallet. What did you do at that point?
Well, I decided, I thought maybe I misplaced it somewhere, so I looked all over the place. It was not there. So I called his cell phone, which is the only number I have, and I left message after message to call me back to see if maybe he saw it somewhere. And he never called me back for days and days and days, and I didn't hear from him until like 2 days ago. But I started getting overdraft charges at my bank. They started mailing me overdraft charges.
Give me the date that he was there.
February 17th of this last year.
Okay, go ahead.
So they gave me a printout of my bank statement. So I have here printed out, circled the ones that I did not do. So they went and they started filling out paperwork to do an investigation to find the money. So all my money is on hold, but I have proof here from that. So I went to the places on the paper to talk to the people that work there, maybe get receipts.
Were they stores?
Yes, they're stores and a gas station. And I got credit slips.
Purchased from?
Pyromania Glass Studio.
What is that?
It's a glass blowing place. They buy glass floats.
Uh-huh.
I mean, that's all I saw when I went in there.
Okay, and what other store?
Chevron gas station.
So whoever it was who took your wallet made a purchase and used a debit card for $145 for a piece of glass.
Yes.
And then $30 for gas.
Yes.
Okay. Were you able to get the receipts?
I was, and they made copies for me. And right now, I have a witness right now, Rena Salzer, who is a handwriting expert, and she can verify that those are Scott's handwriting.
So on the 17th, which was the day he left, left on the 17th. So on the 17th, someone purchased this piece of glass for $145. And then on the 18th, someone purchased gas for $30.
And I knew that wasn't me. I only get gas in Toledo, so that wasn't me.
And this is in?
Newport.
Newport?
Oregon.
Oregon. Where does he live?
Newport, Oregon. Well, I don't know where he lives. He stays wherever he wants, but...
Is that where you were living, in Newport, Oregon?
I am now. I wasn't at the time. I was living in Toledo.
What are you doing in Newport, Oregon now? Who lives there now?
That's just where I ended up living, just because I didn't feel like living with my parents anymore. Didn't feel like staying with my mom's. And as far as her wallet goes, I would have been gone the day before, but she refused to give me a ride home. And I've never seen her wallet. I have my own.
Ah, you have your own wallet?
Yeah.
But you don't have your own debit card?
I don't need a debit card.
Okay. Let me hear you witness. Is that you?
Rena.
Step up, please. Tell me your name.
Rena Salzer.
Ms. Salzer, I have a few preliminary questions before I can permit you to testify as an expert witness. First, I'd like to ask Mr. Gifford, I want you to look at these two documents, sir. I want you to look at the handwriting on these two documents, and I want you to tell me if you recognize that handwriting.
Nope. Looks like it could be anyone's handwriting to me.
I didn't ask you that.
No, don't recognize it.
Okay. How long, by the way, did you live together?
Off and on for about a year. We were only dating for a couple of months.
And how old is your child?
She'll be 2 on the 2nd of May.
Okay, but you lived together for a year?
Off and on.
Off and on. Who paid the bills?
Me.
I just have to know whether he had an opportunity to see your signature.
Yeah. Well, my license was in my wallet also. And on the license,
it's signed.
Your signature, yes.
Okay. All right, Ms. Salzer, have you ever testified as an expert witness in any court?
No. I've worked with attorneys on various cases that have involved questioned documents, but none of the cases have gone to court.
Okay, so you have been utilized by attorneys, by private
Correct.
attorneys. Are you registered anywhere as a handwriting analyst?
Yes, I am on the public defender's list.
Where?
Los Angeles.
What kind of credentials do you have to present in order to go on the public defender's list?
I have to present my education in the field, as well as the fact that I have apprenticed with a board-certified document examiner for the past several years.
With whom have you apprenticed?
Eva Salzer,
Is that your mother?
in-law.
Mother-in-law. But you have been certified to be on the public defender's list as an analyst in documents.
Correct.
Okay. Did you have an opportunity to examine this document?
Yes.
You have to look at it first.
And I also have exemplars of Mr. Gifford here, if you would like to see them.
How did you obtain the handwriting exemplars of the defendants?
They were given to me upon my arrival here today.
Here.
Correct.
Good. So your analysis of the handwriting was really done today.
Correct.
Can I see the handwriting exemplars that were furnished by Mr. Gifford? Would you show these exemplars to Mr. Gifford so that he can verify that this is his handwriting? Is your handwriting, is it not, sir?
Yep, sure is.
Okay. Were you able, Ms. Salzer, to draw with a reasonable degree of scientific certainty a conclusion with regard to whether it was Mr. Gifford who signed the plaintiff's name to these two debit slips?
Yes.
And what was the conclusion that you drew?
My professional opinion is that it is highly probable that Mr. Gifford executed the questioned signatures.
Real cases, real people. Judge Judy. Carrie Soule claims ex-boyfriend Scott Gifford stole her wallet and used her debit card. Testifying on Carrie's behalf is handwriting expert Rena Salzer.
Now, on what do you base that?
The idiosyncrasies present in Mr. Gifford's handwriting, or his signatures, are also present in the questioned signatures of Ms. Soule.
Explain it to me. I have both in front of me.
Okay. The formation of the capital S is identical. It is a rather peculiar formation at that, so that is definitely an identifying characteristic. They both have the same slant and letter proportion. You'll notice that the height of the upper extensions goes quite high up.
Mm-hmm.
The I dots are dashed. The connecting strokes are rather jagged, so the movement of the writing is very jerky looking. The relationship to the baseline is also consistent. It either rests on it, goes a little bit below, or a little bit above. The stroke structure of the small a and o is also formed similarly, an initial loop that is horizontal in the way that it is formed. The combination of all of these characteristics tells me that the writer of the questioned signatures and the exemplars of Mr. Gifford are the same. The only thing that would make my opinion stronger is if Mr. Gifford were to sign Ms. Soule's name right now.
Well, the problem is he is already on notice, Ms. Salzer, so that...
Okay.
Do you understand? He's
Yes.
already on notice that that's what you're asking him to do. But I have followed very carefully your testimony with regard to the various structures of the letters, with regard to how he dots both signatures, the letters that you refer to. So I believe that you are, in all probability, correct with regard to your ultimate analysis, that within a reasonable degree of certainty, you can say that the same person signed these documents. Mr. Gifford, let me explain something to you. This is not a criminal proceeding. I don't know whether in a criminal proceeding, certainly you had the opportunity to take the plaintiff's wallet. You probably had the inclination as well, because according to you, in the few words that you said so far here today, you were royally annoyed that she would not give you a ride home. I have examined these handwriting exemplars that you gave as relating to the documents that were signed, the forged documents, and I do believe that you forged a signature, which means that you stole her wallet and her debit card. Could I say that beyond a reasonable doubt? Probably not. Fortunately, in this proceeding, that is not the burden of proof. The burden of proof here is a mere preponderance of the evidence. More evidence than not that you're a thief, which I find. Judgment for the plaintiff in the amount of $175. That's all.
Parties are excused. You may step out.
He's been stealing from a lot of people. He stole from me before, and I should have known better.
There's a bunch of people that could have a bunch of different signatures. I was out camping, still have no clue what she's talking about.
Stay away from men like that.
Thought that I don't want to be with her.
And now the next case.
All parties in the matter of Solomon versus Guerrero, step forward, please.
23-year-old administrative assistant Desiree Solomon is suing her former live-in boyfriend, 31-year-old salesman Anthony Guerrero, for carpeting, a bedroom set, and a cell phone bill. Anthony is countersuing. He wants the big screen TV.
Ms. Solomon, according to your complaint, you and the defendant were in a relationship. You moved into a home that was owned by the defendant's mother.
Correct.
You say it was in relatively poor condition at the time. The defendant had his daughter living with him. Is that right, sir?
Every other weekend.
You worked on the house, cleaned the house, did some painting. But in addition to that, you claim that you purchased carpeting for the house.
Correct.
You purchased a bedroom set for the defendant's daughter.
Correct.
And then there was an issue of a cell phone bill. You separated because you claim there was some sort of an altercation with the defendant, and you want to be reimbursed for the carpeting, the cell phone bill, and his daughter's bedroom set. The defendant says that the carpeting was your idea, that the bedroom set was also your idea and a gift to the child, and he doesn't know anything about the cell phone bill. We'll get to that. But he is counterclaiming because he says when you left, you took a large screen TV that belongs to him. Correct?
Yes, ma'am.
Okay. When did you separate?
September of 2001.
When was the carpeting purchased?
August of 2001.
Now, tell me about the carpet purchase.
I spoke with Mr. Guerrero, and he didn't have good credit because he had a bankruptcy on his credit due to a DUI, and I purchased the carpet for the house.
No, that doesn't tell me anything. That doesn't tell me that it was a loan.
Well, he knew that was an agreement. He told me he would pay me back for this carpet if I purchased it for this house.
Tell me the conversation as you remember it.
I think I remember it. We talked to each other on the phone, and we came to the agreement. He had some green carpet in there that was his mother and his stepfather lived in, and he smoked, and the carpet was just kind of like riddled with smoke, and his dad, I think his stepdad was like alcoholic, and it just didn't have a good smell to it.
Let me hear the conversation. Usually when two people are living together and they want to buy something, they say, listen, the carpeting is really gross.
Right.
Now, let's get rid of it.
And that was the conversation, and he agreed to pay for the carpeting.
Is that right, sir?
No, ma'am.
Let me hear the story.
Your Honor, if we would have had a conversation like that, we probably would have had it at the house where we sit down and made a decision
Tell
like that.
me
There was
how
no
the carpeting came to be put down in the house.
She went to the carpet place, picked the carpet out, picked the design of the carpet, made the color of the carpet all by herself, told me, hey, can you take this day off? I bought carpet, and they're going to be putting it in this day. Can you take this day off and be there to do it? I said, you did what? And she goes, yes, I got carpet. I go, why? Well, it doesn't match the furniture. It's green, and the furniture is, you know, a beige color. And I'm like, I guess. I was there. I was there to when they put it in, but in no way did we have a conversation stating anything about, hey, let's go get carpet.
All right, let me hear about the bedroom set, Ms. Solomon.
Okay, Tony, when he moved into the house, I had my own bedroom set that I brought in, and he didn't have any furniture. I brought the furniture in. And of course, he wanted to get a bedroom set for his daughter, make the room kind of nice for her. So we went out together and purchased a bedroom set for his daughter using my credit also.
So?
He told me he would pay me back $100 per month for this bedroom set.
Tell me about that.
Actually, she wanted to get this certain bedroom set for my daughter. You know, like she said, my credit wasn't the best, so I was going to go out and get my daughter a nice bedroom set, but not the bedroom set that she had chosen. But she wanted to get that. Anyway, neither way, I have 5 canceled checks right here along with the receipts showing where I paid $500 to her with the furniture, or stating on it right there, furniture to Desiree Solomon.
That was for your daughter's furniture?
Yes, ma'am.
Let me see it.
And this is also a copy of the receipt where she purchased that.
And also, here's a check that he bounced to me.
Just a second. Did he give you $519 towards the furniture?
Yes, and that was with the cell phone bills. He told me he was going to help me pay for the cell phone bills.
Just a minute. This says furniture on it.
Yeah, I know, but 1 month it was for cell phone bills. He paid me 2 payments in 1 month, and one was that to help me with the cell phone.
How much was the furniture?
$579, Your Honor.
Is that right?
Yes.
So he practically paid you for the bedroom furniture.
Correct.
So what do you want?
I'm wanting the carpet. The carpet.
Carpet you're not going to get. Carpet, I don't believe that you had an agreement when you purchased this carpet that he was going to pay you back for it.
I wouldn't have purchased the carpet if he wasn't going to pay me back. I don't have that kind of money.
I believe that he said he would buy the child's furniture and that he would reimburse you. I don't believe you with regard to the carpet. That's my prerogative. That's my job. Okay, now let's get to the cell phone bill.
Here's a cell phone bill.
Show it to him.
Your Honor, we broke up in September. She has bills here for October.
Because you told me to keep the phone on and you would pay me.
She has
Because
bills.
I didn't want to get charged an early termination fee, $150.
I don't even know what she has on here.
It's your phone number.
Did anybody use the phone after you separated?
Yeah, he did.
Did you pay any of those bills?
No, ma'am.
You did not. All right. So
I asked her to send me a list so I could look at phone numbers, Your Honor, and she sent me one piece of paper saying an amount on there, and that was
But now you looked at the bill.
Yes, Your Honor.
Okay, and how much is that bill?
Altogether, $399.17.
So between that and the $79 that he owes you still for the furniture, because he only gave you $500, the furniture was $579, that's $478.
Correct.
Okay, good. Now, tell me about this big screen TV.
Your Honor, one day I came home from work. She's a very materialistic person. She wanted this, she wanted that in the house, she wanted everything perfect in the house, so she could have people over, show everybody how nice our house was.
Good, but that's what
Okay,
women
that's
do.
fine.
Women nest.
I come home from work one day.
Mr.
she
Guerrero,
has-
women nest. You don't care if the carpet is green and the furniture is orange. Men don't care about that. There are some men that care, most don't. Okay, so she's materialistic, she wanted her house to look nice.
Right, so I came home one day, she says, I'm walking in the living room to the TV room, she's standing there looking like Vanna White with a big TV. And she tells me, this is for you, now you can have your friends over here. Because there were times on the weekends where I was going to my brother's house, my cousin's house, watch football, they had big screen TVs. She goes, this is for you, I bought this, you can have your friends over here.
So what you're telling me is she bought the TV as a gift for you.
Right.
And then when she left, she took it.
Right.
Try this, sir. This is so you can have your friends over and watch TV.
Mm-hmm.
Try that. Does that sound right? So you want the TV and the new carpet.
Right.
She's got the TV now, right?
Right.
She keeps it.
Okay.
Perfect. Okay?
Yeah, I've been making payments on it. I had the statement here. He's suing for $3,000. I think it's kind of funny. The TV's only $2,000.
Listen, you keep the TV.
Okay.
Out of this deal, it cost you a little bit of beige carpet?
It cost me more than that, you know.
Probably. And a cell phone bill. All right. He owes you $478, judgment for the plaintiff.
William Russell for unpaid car payments and car damages. William is countersuing for the return of an engagement ring and a broken apartment lease.
Order. Come to order. All rise. Yeah, this is case number 52 on the calendar in the matter of DeFrank versus Russell. Parties have been sworn in. Judge, you may be seated. Folks, have seats, please.
Mr. Frank, while you were engaged to the defendant, according to your complaint, you financed a car for him. He couldn't get credit on his own.
Yes.
The engagement was over. He left with the car, and he said that he was going to maintain the car, make the car payments and the insurance. According to you, he stopped making the payments on the car. You repossessed it.
I took the car back.
You repossessed
Yes.
it. And you want him to pay for his missed payments. And in addition, you said that when you got back the car, it was A, filthy, and B, the brakes were bad. So you want him to pay for the brakes and, I guess.
A window was off track.
What do you mean off track?
They had to order a part to put it back on.
Ah.
I have the receipt for that.
And then he has a cross complaint, which I will get to in a minute. When did you separate from the defendant?
October 2000.
And when did you repossess the car?
March of 2001.
And when did he stop making the payments?
He never paid the payment for November, and February he missed another payment, so that's when they started sending me the delinquency notice.
How many missed payments did he have?
2.
Is that right?
I missed one payment. Double number.
You did. You have proof of that?
Don't have a receipt.
Well, where do you expect me to go to find it? That's what you're coming to court for. You're coming to court because she says that you missed payments. That's what this whole case is about.
I stopped making payments.
So you didn't pay February's payment.
I doubled it.
strength of the old days, standing on this ground, seeing through their ancient haze.
Now, what are you doing with the car?
I search for knowledge in the ruins, not in the newest screen. I honor the silent sacrifices of the lives that intervene. When the world gets too loud and the future feels unknown, I listen for the rhythm in the marrow of my bone. There's a silent, powerful wisdom flowing through the time, a heritage of courage that belongs to me and mine. Hear the ancestors echo in the wind that blows today.
How it was returned, how when I picked it up, how.
I'll take a look at the photographs.
And then I had cleaned it up. I have pictures of that also, what it looks like afterwards.
He's a slob. So? He's a slob.
And that was, that's my car and how I got it returned. And I had to clean it up in order to sell it, and it was a lot of time for me.
He's a slob.
The car was fine when I had it. I mean, I got a letter 3 weeks after she had it.
Just a second. I'm not talking about the mechanics of fixing it. You have a car that's a couple of years old. Sometimes it needs brakes. He didn't break the window. It was a mechanical thing that happened with the window. Is that right?
Yes.
It's a mechanical thing that happened with the window. All I said was he's a slob.
I cleaned out the car before I gave it back to her. I cleaned it out on March 6th.
Well, whatever. You don't get reimbursed for that, but you do get reimbursed, madam, for your car payments that you made. You were very fortunate that you got somebody else to take over these payments. And I hope it teaches you a good lesson. Do not ever finance a car for anybody. Boyfriend, fiancé, husband, child, nothing. If you finance something for somebody, don't treat it as a loan, treat it as a gift. And say goodbye to your money. Is that good advice?
It's very good advice. I'd like to talk to you later about a loan.
We've known each other a long time.
That's right.
Happily.
That's right.
Forget it.
Okay.
All right, so $989. That's on your side. Now, Mr. Russell, you have counterclaim.
Yeah.
Let's talk about your counterclaim. You want the return or value of a computer. Let's talk about the computer.
On June 8th, she gave me the computer as a birthday gift.
When was your birthday?
June 8th.
And tell me how she gave it to you.
We both went down to the store and purchased it.
What'd you give her for her birthday?
Engagement ring.
That was nice. And when was her birthday?
May 19th. March 19th, I'm sorry.
March 19th. So she got the ring first,
Yeah,
and then she bought you the computer.
yeah.
How'd she get it back?
On October 13th, I caught her with someone else, so she moved out. And the next month, she came and got her furniture. Now, if the computer is hers, what?
Just a second. That was in November. She came and got her stuff.
Yes.
Okay. So far, you still have the computer?
Yeah.
When did she take the computer?
When she came to get the car, March 7th.
Really?
Yeah.
Is that right?
Yes, that's when, because I had a police escort, and when I went to go get
When you moved out of the house,
Yes.
you left the computer.
Because he told me that he had stuff to delete on it, he couldn't do it right away, so I'm like, you know what, I don't have time
November,
for this.
December, January, February, 5 months later, the computer's still at his house?
Well, because I had went away for a little while, I went back to New Jersey, I came back and I decided to get my, that's when I found out about the repossession of the
He says it was a
car.
birthday present.
No, I have the receipt right here.
I believe you have the receipt. He says you bought it for him as a birthday present. Let me see the receipt.
Might have been an assumption.
Just a minute. You bought the computer the day before his birthday. That's a coincidence.
But I mean,
That's a coincidence, and you left it in the house when you moved out.
Because he had stuff on the computer that he couldn't delete right there.
That's an hour. That's 2 hours. That's a day, not 5 months.
Your Honor, the MSN was under her name. I made the monthly payments on that for the online use. And she asked me to ask my new roommate, Matt, if he could put MSN under his name. If the computer was hers, why would she want him to put it under his credit card name?
No, I believe it was a birthday present, because it was better times. It was much better times.
Real cases, real people. Judge Judy. Carla DeFrank says ex-fiancé William Russell owes for car payments as well as damages to the vehicle. William says Carla won't return the engagement ring.
On one side, we have $989. That's on your side. On your side, we have computer. That goes back to you. Then you're suing her for the engagement ring, right?
That was because she took the computer.
But if you get the computer back, she can keep the engagement ring?
Yeah.
That's very, very nice of you. Great. So you don't want the ring back as long as you get your computer back.
Bad luck.
What?
The ring was bad luck.
Very.
Perfect. Is that the ring?
Yeah, that's
Can I see it? Oh, it's very pretty. Very pretty. He wants you to have it.
Thank you.
It's yours.
Your Honor, I'm also suing for the $2,000 on the car because I'm selling it to the new person, and the blue book is $9,000 to $12,000. I owe $14,000 on it. So for the $2,000, no, even if he
No,
drove,
darling.
even if he had
No, darling. Did he have anything to do with finding a new purchaser for the car?
no.
You've sold the car. You came to a price with the purchaser. If you had the car and said, I want to sell it, and whatever the difference is he would be responsible for, then I would say you jointly get together, get the highest possible amount that you can for the car, and then if there is a shortfall, just like you were a bank, he would be responsible for that. But you can't do that if you found the purchaser. You got it? Good. That makes sense to you?
Makes sense to me.
Good. Okay, so the computer goes back to him, and you get to keep the engagement ring, which you could probably sell. Ordinarily, the engagement ring goes back to the person who gave it to you. So I would say that if you're out of pocket any more money, what you do is sell the ring. Okay, now, you want to talk about any rent that you say she owes you, or you just want to forget that?
I want to talk about it.
You want to talk about it?
Yes.
Go ahead.
We signed a year lease. She moved out October 14th, and the lease wasn't up till January 14th, 15th, and that's $325 a month as half the rent. For 4 months, it's $1,300.
When did you get a new roommate?
December.
So she moved out in October, and she paid October.
Yeah.
Did she pay any for November?
No.
Yes, I did.
She says she paid some in November.
No, she didn't, and she harassed my roommate about.
Shh. I don't give she harassed your roommate. So far, she moves out in October, and if your roommate moves in December, that's at most 1 month that you're out, not 4. You're suing for 4 months' rent. You don't expect to get rent from her and your new roommate.
She's harassing him for her security deposit back. She broke.
Just a minute.
Huh?
She has security deposit?
Yeah,
How much?
$325.
There you go. Leave the place in good condition. That way you have the security deposit.
But she
But
wants
she's
that
not,
back.
Well, she's not suing for it. So, if you say she owes you for 1 month's rent for November, then you have her half of November's rent, right?
Yep.
Because you have the security deposit. Are you the new roommate? Be neat. What else?
That's it. You're
Did I
right.
resolve this? Wonderful. $998 judgment for the plaintiff. The computer is to be returned within 5 days. That's all. Be happy. Goodbye.
Parties are excused. You may step out.
She owes somebody for her breast enlargement.
My breasts are already paid off, and I don't need his money because he never gave me any money. He didn't have any money, so I wouldn't go after him for money.
And now the next case.
All parties in the matter of Underwood versus Shells. Step forward, please.
Marceline Underwood is suing 36-year-old postal clerk Sheila Shells. Marceline claims Sheila's son, 14-year-old Jamal, smashed her son's glasses in a fight. Jamal says Justin was teasing him in class.
What's your first name?
Justin.
And yours?
Jamal.
This case is about some broken eyeglasses, and there was some sort of an altercation at school, and it is your claim that the defendant smashed your eyeglasses. Is that right?
Yes.
So why don't you tell me what happened?
We was having music, the 6th period of class, and it was free time. So I was joking around, laughing. I was with another boy. I was like, boys should not wear sunglasses because they look like, and I guess he was in my conversation listening. He happened to have on some sunglasses. So
Was he
got,
the only one who had sunglasses on at the time?
I don't really know. I don't think so, but
What were you talking about sunglasses for? That seems to be like a sort of bizarre...
because we was talking about each other, but he wasn't in the, and then...
No, I'm not finished with you, Justin. We're going to do this slowly. How many other boys were you talking to?
3.
Do you know their names?
Zachary, John, remember the other one?
Was Zachary wearing sunglasses?
No.
Was John wearing sunglasses?
No.
And this boy whose name you don't remember, was he wearing sunglasses?
No.
So you made a comment about boys wearing sunglasses.
Yes.
And then what happened?
He got up, and then I got up, and we started fighting.
Just a minute. He got
up and came over to me.
Got up and came over to you. And what did he say when he came over to you?
He just started swinging at me.
So he...
Yeah. And then I got up, we started fighting in the middle. Then that's when he knocked my glasses off. Then as he was moving back and forth, you know, he was stepping on them. Then that's when the kids had to hold me back. The teacher tried to, but I guess he almost swung and hit the teacher.
Real cases, real people. Judge Judy. 13-year-old Justin Underwood claims classmate 14-year-old Jamal Shells intentionally smashed his glasses. Jamal says Justin was teasing him.
Now it's your turn, Jamal.
Yes.
So you overheard this comment about sunglasses.
Yes.
You got mad?
Yes, ma'am.
And you went up to him?
Yes, ma'am.
What'd you do?
I hit him in the face and knocked his glasses off.
And?
And then we continued fighting. He hit me in the face, and I kept swinging and pounding on him. And then, like a mob of kids, you know, that were in the class, they came and broke it up. And
okay, good. How come you got so mad when he said something about your sunglasses?
Well, that was like 2-3 months ago, and we didn't really get along at the time because he talks a lot and he just gets on a lot of people's nerves.
But what'd you get up to hit him for?
Because he was doing it for a long time, so I just got tired of it.
What was he doing for a long time, Jamal?
He kept egging me on and messing with me.
Like what?
Calling me names in class while I was trying to do my work.
Like what?
Big head, meathead.
And that bothered you?
Yes, because he kept doing it. That's what he does, and I just didn't like it.
But you can't hit somebody because you don't like what they say.
I know, but...
That's not the way to resolve something, by going up and punching him in the face.
Right.
You knew that, right?
Yes.
So what'd you do it for?
Because I was tired of it.
Because you couldn't control yourself?
Yes.
Were you with other boys when he made this comment about the sunglasses?
No, I was sitting down playing cards with a friend of mine. That's when he started calling me with sunglasses and stuff. And I was the only one with sunglasses in the room, so...
Right?
Yes.
Okay, you see how honest he is? There you go. Why were you teasing him?
First, I was not teasing him.
You sure you were teasing him?
He was in my conversation. He should
No, Justin. He may not have been in your conversation, but you were talking to 3 other boys. He was the only one in the class wearing sunglasses. And you made a comment that you knew would be irritating to him. Why?
I don't know.
You didn't think it would make him feel better, did you?
Because we do this we talk about each other all the time.
Well, does he ever talk about you?
Yes.
How?
Fat lion, old fat lion. That's his favorite word. He always would say that.
To who?
Me, in
class. Did you ever call him an old fat lion? Come on.
Yes.
Okay, so you called him an old fat lion. And did he ever hit you?
No.
All right. So, Jamal, that was the wrong thing to do, to hit him.
Yes.
It's the wrong thing to do, to tease. But I gather you tease too. You just don't think that your talk is teasing. You tease each other, right?
Yes.
Now, but for the fact that you punched him in the face, his eyeglasses wouldn't have fallen off, right?
Right.
Then you're responsible.
Yes.
Perfect. So what's the problem? Now I'm talking to your mother. Why didn't you pay for the glasses?
Because I didn't hit Justin in the face.
No, but your son did.
Yes, he did.
Now, as between you and Miss Underwood, he's your responsibility. He's her responsibility. But somebody's going to pay for the glasses. Why should it be the mother whose son did not knock the glasses off as opposed to the mother whose son did?
Because the glasses simply fell to the floor. And from my understanding, the other children, this is what Jamal told me. Another child picked the glasses up and threw the glasses.
Okay, so let's get it straight now.
Yeah.
That's not what happened. That's not what happened.
What happened?
Even if it's so that happened, your son was smart enough to just acknowledge to me that but for the fact that he hit him in the face, the glasses would not have fallen off. And they would not have gotten broken, however they got broken. Let me see a bill for the glasses. Where are your glasses? Where are the new ones?
I didn't purchase any new ones.
Why not? Why not?
Well, I was going to wait and see what happened, and I was going to get him some.
When did this happen?
In February.
Are you telling me that your child has been without glasses since February?
No, he was using his old pair.
But that's not the right prescription.
That's correct.
Well, that's outrageous. Judgment for the plaintiff in the amount of $211. That's all.